you can channelize yourself and then start preparing for judiciary and crack the exam. So first of all, let me show you certain slides that how you have to go about. Now in this, first thing that we are talking about here is, this is find you the calling, which means what keeps you motivating and allowing that how and when you want to become a judicial officer. Why you want to become a judicial officer? Something might attract you, something might motivates you for becoming a judicial officer. So in that case, what keeps you motivating, you keep that intact for a longer time period, because it is all about a competitive exam that you have to prepare about. It is about the judicial exam. Then the second slides that we saw about is, and how you have to go for the preparation, is you must go through the syllabus, as we are having a different state patterns, and then you might be preparing for more than one state in a judicial exam. It is a little different from the IAS pattern, because IAS level is conducted at the center level, and that is why they have a uniformity of the syllabus. How far as this judicial services are concerned, every state has some different subjects, and for that you just keep focus on which state you are preparing for. Which means that suppose if you want to go in for say Delhi Judicial Services, so if you are going for the Delhi Judicial Services, you must keep in mind that apart from the major laws which are there, which is everywhere, likewise your CRPC, your CPC, your IPC, then your Indian Evidence Act, Constitution, Indian Contract Act, some Partnership Act, so on and so forth, they are having certain additional subjects also. The additional subjects are such as the Arbitration Act, that is specifically there in Delhi Judicial Services. If we talk about Punjab Judicial Services, now for this they have an additional subject known as TPA, that is Transfer of Property Act. They may have registration also, Registration Act as an additional subject. Then they have Haryana Urban Rent Control Act also. Then they have the Customary Law also, which is an additional subject. So you must focus on which state you are preparing for. For example, if you are preparing for Punjab, if you are preparing for Haryana in that regard, or if you are preparing for Delhi Judicial Services, these are certain different subjects that you have to prepare along with the other subjects which are common in every state. So for that you should see the syllabus, that what is the syllabus this particular state is offering, and then start preparing from those subjects. This is one aspect, that at least bifurcate your syllabus, see what the syllabus is there, and mark out the subjects also. One subject which is common for every state, and the other subjects which are different in different states. So it is not necessary that you want to crack and you have this only. You can prepare for one single state also. You can prepare for the variety of the states, because the major laws are the same laws. Only difference is that there are certain laws, minor in the sense, that will be different subjects. Now if we go about this also, then it says that you must know the whole syllabus and the exam pattern for making the preparation strategy. Now, how you have to prepare and make the preparation strategy? See, in this case, first of all, once you have made a diagram or a bifurcation of your subjects, then what else you have to do? You have to strategize yourself that how these things will work. That means if you want to go in for preparing first the common subjects, which are very common, and these are the procedural subjects which will come in every exam, be it your higher judiciary, be it your lower judiciary, be it any state. Now for that, once you have to start preparing, you have to analyze certain last year papers also. How the CRPC is going about, how the CPC is going about, and Indian Evidence Act. For that, you also must read the judgments, then in that case the judgments also have to be taken into consideration. Likewise, you have the Supreme Court, you have many apps that is going on. These apps are like Live Law is there, Manupatra, and other subscriptions you may take. You may not take the subscription, but if you start reading the judgments, many of you might have a background that in your family some are the lawyers, and then you can take the help from those generals which they are having. So in that case, if supposedly you have to start preparing the CRPC, first thing what you have to see is mark out the syllabus, check the tenures, and then prepare which are the topics that are frequently coming. What we are saying here is that these are certain topics that you have to frequently check. Suppose in CRPC, major things are arrest, then FIR, then is your bail. From here, majority of the things will also come. There are certain other topics. I'm just taking an example that arrest is there, FIR is there, bail is there. So in these circumstances, these things have to be checked and read properly, which means first, you have to read the bare language. Unless and until you will not read the bare act, you will not be able to get the clarity of what they can ask you. Plus, with the bare acts, you must read certain books. If you are taking some coachings, definitely they will be providing you the material, the reading material, the judgments also that you must focus upon. So what the second point talks about in the PPT, the presentation, it says, you must know the whole syllabus. What is the syllabus exactly? You cannot take a chance that, okay, registration will come for 2 marks only, or maybe only 2 questions will come from Arbitration Act. I can skip that. You are not supposed to skip anything because you never know. This may be well prepared. Arbitration is well prepared and they may ask you that question also. And then you might get not a chance to clear the exam because you skipped 1 or 2 questions. So it depends upon the variations. As you can analyze the last year results also, it comes in points. So even in a point, you can miss the chance. So if it is 350 and the cutoff was 355.5, you may have missed the chance. So it is 0.5 is the chance that can be missed. Now, with regard to the third part, what we have to see is that what I was telling you, you have to take a look at the previous year question papers. That is for both the aspects. One, the preliminary part, another is the mains part, such as our judicial exam is divided into 3 parts. One part is the preliminary part. Another part is mains. And third part is your interview. Now, the inception, the thinking of the students, generally of the students are, you have to go about with the parts that first you prepare for preliminary, then you prepare for mains, and then for interview. But this is a wrong notion that every person is keeping in mind. Why? Once you are able to prepare for mains, then only you will be able to prepare this and this simultaneously, which means if you have certain notes, that may be handwritten notes, that may be certain books that you are carrying to refer certain judgments, for that you must prepare for mains. You must synopsize your notes also in such a manner that these are the questions which are coming for the past 10 years. At least try to evaluate the last 10-year papers so that you can get an idea what is coming in your judicial exam. It will definitely, as I said, will vary with the state to state pattern. Now, with regard to the preliminary part, what you have to see, it is more in a form of an objective test and certain prudence is also required. Now, what is that prudence? First of all, when you study law, maybe from any of the universities, NLS and the other universities, most of you are in a habit of cramming the sections.
This will not help in the judicial exams. Only cramming will not help you out. What you have to do is the prudence test that has to be applied. That what if I would have been in that situation, how I would have behaved. Had I been in that situation, I would behaved in this manner. Then this is what a prudence test is all about. So it is more like an objective test in which you will have a multiple choice questions. In those multiple choice questions, some may be very straightforward questions, that the plea of alibi is under which section of the Indian Evidence Act. That is very simple. Anyone can mark it. That is section 11 of the Indian Evidence Act. But if we talk about the prudence, there are certain questions which are applied form of questions. Theoretical, no theoretical question, rather a prepositional form of question has been applied. Now, what is that prepositional form? Prepositional form is A had the intention to kill B and A killed B. How will you apply? Whether A had killed B because there was sudden and grave provocation given by B. So in a reality, who was the aggressor? Who was the attacker? That has to be checked. And for that, you must know what the law is all about. And you will not know the law only by reading the Bare Act. You must substantiate your Bare Act with the judgments as well as with the notes that you are preparing either on your own, either with the help of the teachers or the coaching institutes, right? So this is one aspect. So first, mains has to be prepared first. Why? Because once you clear the PT, when you are aware that yes, we have cleared the PT, you will hardly get 2 to 3 months at the max to write the mains. And it is actually the mains that will assure you the rank, that will assure you that actually you are going for the interview or you're not facing the interview. There are so many students who may pass in this, who may not pass in the mains. Why? Because they have not prepared together all these three stages. One should not keep a wrong notion, a perception in mind that only preliminary will be cleared and then it will be a mains and then it will be an interview. These three parts and phases will go hand in hand together. It cannot be read one as one part, another separately. So one, you have shortlisted your syllabus by looking into the 10-year exams. As you all know, because you are preparing for judicial exams and how you have to prepare, you must show the index of a Bare Act. You must see that. Once you see the index of the Bare Act, then you will see that there are the indexes, there are certain parts and chapters in which the whole of that particular one provision has been divided. Now, once you have seen the tenure also, mark those things. Suppose this is the index and there are these provisions. Sections have been mentioned here, like 1, 2, 3, 4. Now, suppose this is coming frequently. Likewise, section 2 is coming frequently. And out of section 2, many other things are coming. So you just mark it twice and thrice and read it more. I am not saying that you can skip the others. You have to read for preliminary and mains part each and everything of the Bare Act. Everything of the Bare Act, which means you are not supposed to leave the Bare Act. Even a single section cannot be left. So, but I am saying that first you should consider what are the important topics. I should go with those important topics first, and the second reading would be of the other topics which may not be covered but which may come in near future. So in that case, you have analyzed those sections. You have marked certain sections like this and this, that these are the certain important sections that are there. Now these important sections have to be read together with the judgments, right? Now, which judgments you have to refer? As a general rule, it is the apex court judgment that you must refer because they have a precedental value, a binding value. Howsoever, if you are preparing for Punjab Judicial Services, if you are preparing for Haryana Judicial Services, you must go at least for the last 6 months Punjab and Haryana High Court's judgment also, because you are actually preparing for these states. So you must go for the Punjab and Haryana High Court judgment. That is what one thing. If you are preparing for Delhi, if you are preparing for Madhya Pradesh or any other state, at least make it a habit that you should go of the last 6 months their high court's judgments. The respective high court judgments have passed it, and you must go through all these last 6 months judgment. Apart from or in addition to the judgments of the Supreme Court. So the judgments of the Supreme Court has to be read. Now the confusion that a person has in mind, what to read, whether to read a landmark judgment or whether to read a latest judgment. So unless and until the law has not been reversed by the Supreme Court, it is, you can read the latest judgment, because unless and until you will not be getting any information, any kind of guidance from someone else, you will not know that this is the landmark judgment. Because in every book, for every topic, there are 10, 12 judgments, maybe 4 or 5 judgments. How will you know that out of these 4 judgments, this one is an important judgment? So in that case, what you have to see is, you can see that there are certain judgments which are landmark judgments. If suppose you cannot see that, then there will be latest judgment. So today we have entered into 2022. You might see 2021 judgments. And in 2021 judgment, whatever has been decided in 1950, that has also been made a part of that 2021 judgment. So we'll get to know that this is an important judgment which the Supreme Court has cited. So once that judgment has been cited, you will get to know how you have to plan your schedule. And it is one of the most essential part of preparing for the judicial exam, that you should read the judgments. Unless and until you won't read the judgments, it will not help you out. So it is one of the most important things, as I'm emphasizing again and again. Now, third part is, this is your importance of planning. Now, what you see is, there are certain habits of several students, including us also sometimes, that we have 24 hours in a day. Out of these 24 hours, what we see is, we will do this and that. So it's only 12 to 16 hours that you can study, but that cannot be in continuity. That has to be a gradual process. It is not that from the first day you will start sitting for 12 to 16 hours per day. No, the gradual thing has to be increased. One cannot improve a thing, and one cannot be made a habit in a day. Habit takes time to make it. So for this, you should start with at least sitting of 4 to 5 hours in a day, apart from your other work that you're doing. Maybe you're pursuing law, maybe you have just started with the law. So from doing those assignments, you at least start devoting 4 to 5 hours at the starting. But supposingly you have completed your law, and then you are appearing, and then you want to say that I do not know anything about judiciary, I just want to go for the judicial exams. Now what you should do for this, at least, because you have plenty of time and you do not have any other activities to be done in the college or anything, then you can start devoting at least 12 hours. Maybe with the passage of time, you can increase it up till 16 to 18 hours, right? But it depends upon your cognitive faculties also. Some people are in a habit of understanding the concept at once. Some may take more time. So that all depends upon the cognitive faculty. If a person who's able to understand every such thing and able to retain that thing within 12 hours, that is sufficient for him to study in a day. But there are certain students, there are certain persons who may not be able to recollect it. Then what you do? You must go in for more than 12 hours. And another important aspect is introspection. Introspection is what we all do when we have our exams. So for judiciary, it is just a time, it is just a phase which you have to devote time to. It may take 6 months, it may take a year. It should not be more than that, because otherwise you will then end up doing certain other activities. So it may take 6 months, but for that, introspection is there. What is introspection? Suppose if I have read one concept today, after reading that concept, I will shift on to another concept. Now once I'm shifting to other concept, I should actually able to recollect the earlier concept which I have done it. For that, I should give some time, 5 minutes, 10 minutes of certain kind of a revision. That yes, by closing your eyes, by looking into the mirror, maybe by closing yourself in a room, and then start saying, yes, I have completed so and so yesterday, and these were the basic points. Unless and until you won't do the introspection, you will not be able to understand the law. What we do, it is a practice that makes a man perfect. When we teach you here, what we do is, the bare act that you people are reading, even if we close our eyes, even if we are somewhere in a room where nobody is there, We do not need to open a Where At. It is in our minds, it is here, which has been established. So this is what you have to do. It is with the practice. You cannot say that, ma'am, because you people are in a habit of teaching, and that is why you are able to retain it. No, since the time when you are preparing, it is in your mind. So this is what we are saying, that it may be 12 to 16 hours, but you have to improve and increase the time gradually, and also improve the cognitive faculties. We are not saying that a person is with less brain he is born with, and another person is born with a very good brain. No, everyone is born equally. The only thing is how you apply your mind. So this is where you apply your mind for the preparation of the law. So initially go for this, and then at least increase from this 16 hours to another hours. Why we are saying that? Because it is one of the toughest competitive exams, and that too because states are conducting it. So there are chances of increasing one subject here, decreasing one subject there. And you have that because exam day is a fear day, and that day is the day. So how you have to prepare it, that will be exhibited in your preparation, in your attempt. If you want to crack the exam, at least you must be aware of all the laws, whatever is coming in that particular state. After that, you must be aware that you have solved so many MCQs, multiple choice questions, from that particular subject. Suppose CRPC, CPC, there are certain books on this. There are various books of different publications that they offer. 10 years are also there, so that you start preparing those MCQs. No, once you read this topic of arrest, then start solving the multiple choice questions of arrest. Start writing the questions for the arrest for the mains purposes. Unless and until you won't do it, then you will not be able to recollect it and won't be able to write it. Why? It is a time oriented paper. In a period of 2 hours, you have to complete either 125 questions in Haryana and Punjab, 200 questions in Delhi, and different states have different pattern. But the maximum duration is 2 hours. So you have to apply your mind, and then out of these 4 or 5 options, you have to choose the one which suits you. Another thing is that you have to keep in mind, there is a negative marking also. So once there is a negative marking, you must be aware that you are not supposed to write click each and every point. No, you cannot solve each and every question, because supposingly out of these 120 125 question, if 10 or 11 gets wrong, you may lose a chance of clearing the exam. And that is why a proper planning has to be there. What is that proper planning here means? It means, first, as a law student, I should have some notes of a subject. Then I should go through those notes. After going through these notes, I can start preparing for the preliminary part. First, mains has to be sorted out with the help of the Where At. I have my register, I have my Where At. I will read both these things simultaneously. Once I am preparing with this, I may write one-liners fact in a different notebook. So once I'll write these one-liner facts in a different notebook, then this notebook with the judgments will help me when the notification of an exam will be out, and I will have 2 months to prepare for my preliminary. I have already done my mains preparation. That's all done. It's completed. Now what I have, my minimal kind of a notebook plus a Where At. This I will read once the notification is out. So I'll start reading these. And another thing, when I'm saying this, I'm presuming that once my mains is over, the notification is out. But supposingly it takes 2 to 3 months after preparing, and you get monotonous with it, that I've got bored with this and everything, and I do not want to study. Take a break. We are not saying that you people are machine. You people are human beings. You can take a break, but at least give your best before taking a break. You can study for 6 days in a week. You may take an off, half day and off. Maybe the seventh day and half day will be an off, where you can just freshen up your mind. Whatever motivates you keeps going on. You may go in for exercise, you may go in for walk, but you have to keep your mind fresh for that. Whatever is the option for you, that depends upon person to person. So proper planning is this kind of a planning, and we actually tend to plan in such a manner. Whenever we are teaching here, we make sure that the students are writing what we are dictating. These are the landmark judgments, these are the latest judgment. Plus that, we are also make sure that they are reading the Where Ats word to word, because every Where At, in every word, there is a meaning to the Where At. Notwithstanding has a different meaning. Nothing has a different meaning. May and shall has a different meaning. How we have to read? We have to read each and every word together with the other linkages that we are planning. And that is what proper planning is all about. One, you should focus upon the law subject, read the mains, prepare for the mains with the bare ad, then make short pointers, write it in another notebook, and then start preparing for your PT. First important part. Second, that I have highlighted here is language subjects. Some of you are in a habit that we'll prepare for the law subjects. Language we can see later. No, you cannot. You cannot take a chance of seeing it later. Why? The reason is, if you are preparing for Punjab, Punjabi is mandatory. If you are preparing for Haryana, Hindi is mandatory. If you are preparing for Delhi, GK is very mandatory, and there is a translation pattern which you have in each and every state almost. Now in Hindi, the technical thing is, because now we are in such a state of mind, we are in such law colleges, that the Hindi or Punjabi, the local languages, are not a part of our subject. It is only the English language that we get to know. So how you can prepare for the languages? You can always take the help of the teachers, you can always take the help of the books. Likewise for Hindi, you may go in for the MBD guides. You may go in for 10th plus 2 MBD guides, because the basic level will be of plus 2 level, that you might, because a person who belongs to Haryana will definitely might have read Hindi language, maybe in 10th, maybe in plus 2. So this we have to see. For a person who belongs to Punjab, he or she must have read Punjabi as a language. So in this case, if that has been done, so they might be aware of the basics of that law. And after that, what you have to do? Start revising. At least keep an hour for the language. If somewhere the states, there are English also which is coming, the English as a subject is coming. Essay writing is one another important thing in all the judicial exams for mains. And if you are able to score good marks in essay, definitely that will lead and give an edge to you for scoring certain ranks. So what you can do is, you can always go for and spare some time, maybe an hour, maybe 2 hours, for the language paper as well as for preparing the essays. You cannot say that this we will prepare after clearing our PT. No, you cannot, because then you just have 2 months. 2 months means 60 days time period in which you have to revise all your notes. That may be of this much huge capacity. Likewise, if we talk about CPC, we talk about CRPC, there are 600 pages of the notes of a student, which we actually here provided. So what is it? You have to read those judgments, you have to read those notes, and then will you get time after this, within that 60 days, that you can start afresh with the language? The answer is no. And that is why every one single hour, at least daily, you should focus. Or maybe one subject, one day from whole of the other days, you can keep it for your language. This is important task, important tool. Otherwise you will not be able to crack the good exams, and you will not be able to get the good ranks. Now come to the second part, the coaching institutes. See, earlier the perception was the competition was not that much. If we talk about 1980s, 1990s ke aspas, the competition was not that hard, because everybody was not going into it. So, and the people, they were studying in a very better manner, in a good environment, and they were aware of the basic laws as well. So it was not a need that was felt that at that time, that there should be some kind of a guidance. Even the teachers used to guide the students that yes, we are also preparing, we are also giving the exams for some higher judicial, and then you can prepare it in certain manner. Now, because see, the lifestyle has changed, the teachers lifestyle has also changed, it has impacted in such a manner that we are not able to teach you each and everything during the law times. We have to, but see, if CPC and CRPC is to be taught, that too in a year, it becomes very difficult for a person who does not have any background how to create a base. So it takes time for the law teachers to teach you everything. So if the coaching, what is the role of coaching institutes? So see, we are here, we are providing you the guidance for all the three stages. Before that, you have either completed the law, you are pursuing the law, and you have joined some coaching institute. There will be variety of teachers who will guide you. There may be senior teachers, there may be young teachers, there may be those who are also aspiring candidates for judicial services. So they have that knowledge. They are actually keeping intact with the things that yes, we have to study this much of the GK, we have to study this law pattern, and this is how we have to team up work. So in that case, if you have the coaching institutes, if you have joined any of the coaching institutes, the better part or the best part in this is you will get life thinking and a strategized life, so that for a year I have to study in this manner what they will be teaching us. So when you have focused something, when you have planned something in certain manner, we will definitely guide you, because guidance is one of the most important thing that a person requires for preparing these competitive exams. So definitely these coaching institutes which will tell you, these are the landmark judgments which a person who's not from having any background of the coaching, he or she has to read and put more efforts. As far as the other students, we will tell you that this is the landmark judgment that you have to read and this is the latest law. So आपके लिए एक the easy way is that you can always think that this is the proper synopsized manner that we wanted. Otherwise, you have to read the whole CRPC Kelkar, Ratan Lal and Dheeraj Lal, the other notes also. But for us, we are reading each and every book so as to keep intact with the laws, so that we can teach the students also. Because 2021, if I'm not reading any judgment of 2021, not 2020, I am just giving them the old judgments, that will not suffice our thing. Why? Because we have to keep on changing with the Supreme Court's judgments. And that is why it becomes easy for a student who joins a coaching institute that yes, this is how we have to go, and we need not to look here and there. But the other student generally have a tendency of getting confused because they do not have a straight guidelines for it. So this is one of the aspects of the coaching institutes. But we are not saying that it is only because of the coaching institutes. It can be other way around also. You can, as I told you, you can always strategize your planning and see the 10-year papers, and then you can start solving. The only thing is, even if you're solving, how will you get to know that this is a question that I have written and this is the apt answer for that question? Here, we will guide you. There, you may write it on your own and you presume that this is the apt answer that I have written. That is why somewhere people, I'm not saying otherwise, do not take it otherwise. We are just saying somewhere the people may lag for 1 mark or 2 marks in the mains. Why? Because they do not have a proper planning system or a guidance program. So this is one aspect of the coaching institutes that nowadays they are playing an important role in this. Next is practice and practice. This is the sole mantra of clearing the judicial exams. Unless and until you won't practice, you will not be able to complete anything. It is just the practice. Why we right now remember these laws? Because it is with the practice that is coming up. Every time we are reading certain things, and new things come up. Till today, it's been so long that we are reading these bare acts. But whenever we'll read it, something new will definitely crop up. Or when these things are cropping up, you must refer to the latest judgments, as latest judgment plays a vital role in our society. It gives certain things wherein the law as such is a very dynamic concept, and we should keep our dynamism there also. We should not be static like the other things. We should be very dynamic. Why? We have to change and we have to practice. Unless and until you won't practice, you will not be able. See, if you said that okay, after 3 months we have a judicial exam, and after these 3 months we'll give this, supposingly for the 3 months you are preparing, and after that suppose that exam could not have happened because of the pandemic, it got delayed, your preparation will come down. Why is it so? Start preparing, keep it in a sync. That is what I'm saying. At least make the consistent efforts. Consistent effort means if you are preparing 12 hours a day, at least devote 12 hours a day. It is not that for the 3 months you are studying 18 hours, 20 hours in a day, and after 3 months you are just studying 2 hours in a day. So you must be consistent with your efforts. Unless and until you are not consistent, you will not be able to crack the exam. It is difficult exam, and day by day it is becoming difficult because the how you are law students. And one thing keep in mind, that law keeps on changing. It is not that static that what we heard earlier is the same thing. Now earlier times, very earlier times, if you remember, and this is a very basic example that I'm giving you, the teachers, so as to teach the students and so that they can learn it, they used to beat them also. There was slapping also that time. So if we talk about section 95 of the Indian Penal Code, it talks about the law of trifles, trivial nature. Earlier, because it is an 1860 an old law, we could have considered that slapping, a normal touching of a person, earlier it was not an infringement, Nowadays, if a teacher slaps a child, definitely they cannot do so because it is an offense. Offense means it may be a tort, it may be any other penalty that have attracted the teacher. Now, in this earlier, that never used to happen. So, in this case, slapping could have been trivial in 80s, maybe in before 80s, but now slapping, it may be a hurt, it may be a grievous hurt if the slapping was with so much of the force. So the law is changing, so we also have to keep intact that what we are changing in our scenario. Suppose you have entered into a law institution today, you will take either 5 years or either 3 years to complete the law. Within that 3 years or 5 years, definitely there will be a drastic change of your law in certain matters. I'm not saying in every matter. For example, Hindu law. In Hindu law, if we talk about the daughter's right, earlier the daughters were not having that much of the rights, which nowadays, after 2005, they have got. So there is again a change in the women rights also. With regard to Hindu Succession Act, with regard to your Indian Constitution, with regard to the reservation system, if you have seen, there is a woman candidate also in the ministry. Why is it so? Because we are giving the equality. So earlier equality was there because our main law is the constitution, which is there since 1950. Now 1950 itself, they gave the powers to the women also, but they were not that much represented. Now with the passage of time, when you will read the law, you might have read the law, you will see that what are the changes that law has brought in the lives of the woman, in the lives of the children. Live-in relations that were not recognized earlier, the LGBT community rights, the transgender rights, the third right, what it is. We are living in a progressive society everywhere, in a progressive nation, and we need to progress day by day. And that is why we also need to progress in our preparation. And that is what it becomes little technical nowadays, that what the law is. A law may be in a year back, it is a law. Later on, it may not be a law. For example, there was 2 landmark judgments. I'm just sharing an example so that you get an idea that how you have to prepare for the exam. In 1994, a Supreme Court has passed a judgment known as P. Rathanam, in which they said that right to die is a fundamental right. And what analogy they have drawn is that if a person, as a general human being, is having a right to live, he also has a right to die. So this is the analogy. This is the things that they have drawn together, the similarity that they have drawn. Now, after 2 years, 1996, there is another landmark judgment that came, that is Gyan Kaur versus State of Punjab, in which the Honorable Supreme Court has reversed a decision that was held in P. Rathanam, that right to die is not covered under right to life, under Article 21. So see, within a period of 2 years, they have changed the concept. So within that 2 years period, if someone was preparing for law and they have kept in mind that yes, right to die is a fundamental right, and they have not read Gyan Kaur's judgment, what is your perception till today? And what you will teach to the students? That is, right to die is a fundamental right, which is not there. And that is why you keep on changing. You have to keep the pace with these statements. And how you will keep the pace? It is not that you read the Bare Acts and you keep on purchasing the Bare Acts every new year when amendments come up. We have very old Bare Acts. That is not a concern. The concern is you keep the amended copy with yourself, the only copy that has amended few sections. You need not to purchase the Bare Act every new year. That is, amendment has come in the IPC, CRPC in the year 2013. I will purchase the new Bare Act. It has come in 2020. I will again buy 2021 Bare Act. No, you are not supposed to. You can keep your old Bare Acts. You just mark those Bare Acts. One important tip that I wanted to share it with you, that I always keeps on sharing, is this is the Bare Act. This is one provision of the Bare Act. So in that provision, there are certain words that has been written. Now in these certain words, suppose this is one of the most important word. I will highlight it. Don't hesitate that you are not supposed to mark anything in the Bare Act. I do not have my Bare Act with myself right now. I would have showed you otherwise. It is one such kind of a Bare Act which is marked everywhere. Why? Because somewhere it is used may. I will underline that may. Somewhere in the same act, in the same provision, it has been used shall. In the same provision, shall, I will mark. So I will try to relate that why may is used in first part, why shall is used in another part. So you have to keep in mind why this in the same act, in the same provision, in the same section. Suppose there is one section in which both the words have been used. This is one section. right? So in this one section, maybe may is also there, shall is also there. So what we have to see, that what is the purpose of this may and what is the purpose of shall. Now there are certain other words likewise, notwithstanding. Now you must be aware that why we are using this word notwithstanding and why we are using the word nothing. As I told you, every word has a different meaning. Every word in the Bare Act. You must pay attention to the words of the Bare Act, as the preliminary part the preliminary part is always of your Bare Act. There may be certain laws that may have been passed by the Honorable Supreme Court, in which several provisions of the Bare Act might have been created as redundant provision. Redundant means inoperative provisions. Now, if they are inoperative, that has not been deleted by the law in the amendment itself. So that is intact. Now, what you have to see, suppose there is one kind of such example is section 23 and 25 of the CPC, that is Civil Procedure Code. What you have to be aware of as a law student, you have read section 23, that's fine, that you get to know the interpretation also of section 23. Then there is section 25, which is a kind of a riding effect upon section 23. How will you get to know? Unless and until you have not read that judgment, you will not get to know. And that judgment has not been provided in the Bare Act. It's not there in the Bare Act. And even in the Bare Act, the judgment what says is that please do not keep this section here, right? It becomes inoperative. They have mentioned in the judgment itself that section 23, some part of section 23 has become inoperative. But that has not been specified in the Bare Act. Now, how will you get to know about it? You have to read the judgments. And that is what judgment plays an important role in deciding how you know the law. If you are not in a habit of reading judgments since you enter into a law college, then you are actually at a wrong track. For the right track you have to follow is from the first day itself, start preparing your laws. If a teacher who's actually going and who's teaching you, start preparing for that particular subject. You know that from tomorrow Indian Contract Act will start. So for that, start reading, take the Bare Act and then start reading it. If you are unable to do so, then you will not be able to see what the teacher is about to explain you. So you must read before going to the class this concept that what they will be teaching you in a class. If you are not reading that particularly, then there is some kind of a thing that you may lag one way or the other way. You are lagging somewhere. Plus, maybe because first year students have that kind of a charm that no, we have entered into the colleges, now we want to enjoy the college life. We are not saying that you are not supposed to enjoy a college life if you want to become a judicial officer. You must enjoy that, but at least keep some time for yourself so that you can start reading the judgments. So make it a habit. Likewise, I am habituated to read the judgments. So you should also make a habit of reading the judgments. Unless and until you won't read the judgment, you will not understand what this law is all about. Even if you read a basic book, even if you are keeping a basic book, likewise for Indian Contract Act, generally here in Punjab and Haryana, we refer Bangia's book. And for Avtar Singh book is also there for Indian Contract Act. But what is the contract as such? So it is very easy to understand and draw. See, everyone knows that, but the only difference is that they are unable to relate it. Offer plus acceptance is equals to a promise. That we read under section 2 of the Indian Contract Act. Now the Indian Contract Act is an old law of 1872 and still it is prevalent. Why? Because it is based upon a common law system. We have developed this law from the common law. Common law means from the English cases, and that is why they are saying offer. Offer is A wants to sell his mobile to B for worth rupees 15,000. He asks B that will you buy? B says yes, I will buy the mobile for worth rupees 15,000. Offer is made by this A person, acceptance is made by this B person. Then if there is a valid offer, if there is a valid acceptance, there is a valid promise. Now this promises that A has to hand over the mobile to B and B has to pay the 15,000 rupees to A, right? This is what the promise is. Now in this promise, there is a consideration also. Now people are actually misconceive that notion of consideration. Consideration is not monetary. It may be more than monetary. It may be anything. It is the promise itself that A, once he receives 15,000, will hand over the mobile. So A's consideration is handing over the mobile. B's consideration is that he has to give the 15,000 rupees and then only he'll be able to get the mobile. So the consideration is not 15,000. The consideration is in both the aspects, that he also has to pay some consideration and he also has to give some consideration. So this is promise and consideration, which makes it a complementary part, that is agreement. Then there is a term actually which is being usually asked in a exam: all agreements are contracts or all agreements are not contracts. Now the notion here is, it has been provided under section 10 very beautifully of the Indian Contract Act. All agreements are contracts if, so there is a word if. If means certain conditions needs to be fulfilled. So this if as a general English may not have that much importance, but here in the law it has a very much importance. What kind of an importance? Extreme importance. This is if means if certain conditions are fulfilled. What are these conditions? These conditions have been specified under section 10, that there has to be free consent by both the persons. Then both the persons must have of sound mind and of major, that means competency. Then they should be entering for a lawful contract. Had it been a stolen property, whether it was a lawful contract? The answer is no, it could not be a lawful contract because it is a stolen property. One cannot steal the property and sell it to someone else, because that property is not that person's property who has stolen it. So in that case, lawful purpose has to be there. So if everything is there, which means agreement plus the enforceability is equals to a contract. So we generally say, okay, this is a contract. What is a contract? You will read when you might have read that, or you may read it. Once you read the Contract Act, it says any agreement which is enforceable by law is a contract. Now, what is an agreement? Agreement has to be promise plus consideration. What is a promise? Promise is offer and acceptance. What is offer? What is acceptance? What is promise? Consideration, that has to be understood. Plus, to becoming an agreement and the enforceability, what is important? Important is this word if. And that is why we generally have to focus on this if word, that this is where the crux of the section lies. This is how you have to prepare it. Break these sections into as many words as you can and then bifurcate those sections. Suppose, giving you an example so that you can relate it with yourself. If I have to break the same section of the section 10 of the Indian Contract Act, I will say, first part is all agreements are contracts if made by free consent by competent parties for a lawful object and for a lawful purpose. This is the crux of section 10. This is how you have to present the paper. This is one of the ways of presenting the paper. Now, in this way, we are saying free consent. For this also, we have to look into the Bare Act, that where free consent is defined. So they say, if we read section 14, rather 13 till 18, we'll get to know what is a free consent, what is consent, and when the free consent is caused. So these are the certain essential elements of this. Then if we have to see the competency, we have to read section 11 and section 12 of the Indian Contract Act. A person must be of sound mind, he must be of major age. Lawful object, for this we have to see section 23, sections 24 till 30. This we have to see. And in the same way, for a lawful purpose also, we have to see both. Right? This is what we are saying under this part also. So if we are saying free consent, competent parties and everything, just to understand section 10, what are the sections that you have to read? Almost half of the bare act of the Indian Contract Act has to be read if we have to understand section 10. This is how the contract will come into picture. Before that, you cannot say that yes, every contract which is enforceable by law is a contract. No, every agreement, enforceable by law is a contract. You cannot say so. Why? Because for a contract to become, you must see all these essential criteria where it has been provided under section 10. But how you will substantiate your answer? By reading all the other provisions. This is one just example of how you have to start preparing your laws. I hope this was the brief about this area. And if we go about again the starting point, of course, first thing that you always have to keep in mind is what is the thing that keeps you going and motivates you. If that is the one factor that keeps you going on and motivates, please do keep in mind every time, because that is your aim. Why you want to become a judicial officer? You may have been attracted, several of you, when we ask certain persons and students who are actually going in for the interview, and we generally ask why you want to become a judicial officer, they say, ma'am, the aura that is attached with it, we want to go in. See, the aura is with the advocates also. It is not with the status is not only with them. So then they will say that you are coming from the advocate fraternity and you are saying the advocate fraternity is not good, you want to become a judicial officer. That is a kind of a negative impact. What keeps you going on, that you have to see that yes, I want to become a judicial officer because this is one of the best professions, and you want to be compassionate about so many things. So if you are compassionate about this kind of a system, justice delivery system you are inspired by, you may go in for this. What kind of justice delivery system you are inspired by that you want to become a judicial officer? You must go through the judgments, then you will get to know, yeah, this is how the justice is actually going on. Second, I told you about the syllabus. Unless and until you won't prepare the syllabus, you won't look the syllabus properly and will not write it in a notebook and then start preparing accordingly with this, you will not be able to crack the exam for sure. So you have to strategize the syllabus. Then of course you have to see the previous year questions as well. So once you are able to see the previous year questions, you must go through every bit of it, 10 years and the other questions, and then you see this is the important area, this is the most important, this is the important area, this is the least important. We are not saying that leave that least important. No, you have to prepare the least important also for your preliminary part, but at least main important area and the important area should be covered first, and then the least important area that will be covered. Then comes is your another part is importance of your planning. Now, when we are talking about this importance of planning, it says how you put your time, the energy, the efforts. That is what I told you earlier also, that you must develop the cognitive faculties. And one most important part is start doing the introspection. Unless and until you won't do the introspection, you will not be able to memorize the things. Law is all about memorizing and changing of the concept. So what is law, how it has changed, how it has been moved from 1950 till today. So this is how you have to realize certain things, that you have to cover it. Plus the language part, the essay writing, everything has to be started today itself. Some of you might not be good in English, some of you might not be good in Hindi or any other local language. For that, because you are weak in that, you must focus more on that area if you're very weak in that subject. So you should focus on those areas. Suppose if I am weak in Hindi, if I am weak in Punjabi, I should pay more attention towards it, because that is one core area from where I may be lagging somewhere. If I'm lagging there in the language paper, I may not be able to give my 100% best in the law paper. So there has to be some kind of a linkage between each other, that okay, if I'm able to score this much, then this is fine. Otherwise, if supposing the language paper is one first paper, then is your law paper. And you are unable to give language paper. This is the human psychology tendency, that you will not be able to devote that much of the space. Had it been a good paper, then you could not, you would have devoted much good time and a much good preparation also. But if it is a not a good paper, it is just an average paper, then you might not be able to give your best in the other paper. So this is how you have to prepare your weak areas also. Some of you are weak in civil law, some of you are weak in criminal law. Generally people are very good in criminal law because they actually feel that it is easy. The procedure is also technical of the criminal law. So you should prepare the civil law also. And civil law is vast because every state has two papers of civil law 1, civil law 2. So in these two subjects, you start preparing from today itself, as it is a kind of a monotonous kind of a paper that you start going on. What is a matter which is a disputed matter of property? A has taken the property, B wants to get back his property, how he will proceed about. So for that, you must read the civil procedure code. By looking into the whereat, you get afraid of reading it. Why? It's a huge whereat, we cannot read it. But this is not the way of approaching towards the judicial exam. You should read each and every word in the whereat, be it anything which may not be that much important, which may not be for the general parlance also, but start preparing it. Then is coaching institutes, as I told you. This is the way we teach the students here, and that is where the all other coaching institutes are teaching in that way. So this is a kind of a guidance, a bifurcation that we are making it from the other, so that it is easier for you. The step that we are providing is we are just a helping hand to you people. We are providing an edge to you people, right? Then is, of course, the last and the basic thing is practice and practice. The more you practice, the more are the chances of clearing the exam in first attempt. Because if you clear the exam in first attempt, there are chances of reaching you to a larger level, which means if you become the judicial officers at a very early age, you have the chances of going till the High Court, till the Supreme Court. But if you are actually clearing the exam at a very late stage, one thing that crops up in a mind is maybe certain kind of the discouragement that may be there, stress factor is there, and later on you may retire at the district level area only, at the district level judge, and you may not approach to the High Court or the Supreme Court. We are not saying that once a judge is a judge, we are saying that it's a fact. But since you also have to keep pace with the society, as we are saying it is dynamic, you should also make a post dynamic, that once you have approached this level, start preparing more and more. So this is what we are talking about under the practice and practice part. I hope with this you might got the idea that how you have to start with the preparation, how you have to go about. And in case you have any doubt, we people are here to help you out, and anything you can reach us to us. Okay? Thank you so much for listening and understanding. I hope you have understood what we have taught you. Thank you. Any problem, Palak?